Perhaps the state of Minnesota, or at least their legislators, are all giddy about the fact that Aaron Rodgers may be leaving to go to New York. But the reality is their concept about passing this new firearm storage law seems insane, and I can't believe they're considering it in light of the powerful legal precedent against it, among some other practical problems with their ideas. Stay tuned. Let's talk about Minnesota nice, or maybe not so nice when it comes to gun owners. Stay tuned. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the U.S. Supreme Court Bar, and New York Times bestselling author. If you haven't subscribed to the Four Boxes Diner, please do so. Show your love for the right to keep and bear arms and the rest of the Bill of Rights, and show us some love on Twitter if you're interested. Okay, folks, so the state of Minnesota's legislature is contemplating enacting some more strict laws involving firearm storage, which of course is just a metaphor for converting a firearm into a hammer. Because when you lock up a firearm and make it inoperable, it's no longer a firearm. It's now just a brick, if you're lucky. Now, what's interesting, of course, is that the state of Minnesota seems to already have certain rules about locking your firearms up if you're in the presence of children who might get into it, which of course just makes common sense. Basic safety rules and basic non-negligent conduct when it comes to all dangerous items, whether it be firearms or knives or cars or chainsaws or pools and so on and so on. Obviously, if it involves children, you want to make sure that things that could pose dangers to them are kept out of reach. Common sense, basic American law as well, and firearms already fall within that sort of bucket of items in the context of Minnesota criminal statutes. But apparently, the Minnesota legislature seems to have gone the anti-gun bug, probably at the urging of anti-gun organizations that are, pushing them, and they're now contemplating enacting a more strict firearm storage law. But it's really kind of absurd for many reasons. Let me go just through the list as I see it really quick here. Number one, it's likely unconstitutional for multiple reasons. Let us just start with basic Supreme Court precedent. You don't have to listen to Mark Smith. Just listen to the U.S. Supreme Court because, after all, it is the Supreme Court of the United States. Well, the Supreme Court has made clear repeatedly, specifically in the Heller versus the District of Columbia case in 2008, as well as Nysurper versus Bruin, it could not be clearer that the primary purpose, not the only purpose, by the way, not the only purpose, but the primary purpose of the Second Amendment's right to keep and bear arms is to make sure that we as American citizens have the right to firearms and weapons in case of confrontation. Now, another way to use the words in case is in some ways the word if. It's contingent. If we need these firearms for self-defense, they need to be available, operable, and ready. Of course, we don't know when we're going to need these guns for self-defense because criminal doesn't knock. They don't make an appointment and say, we're going to try to rob you, murder you, rape you. That's usually not how it works. They're not scheduling anything. They're just showing up, either in your home or on the streets or who knows where. Again, evil doesn't make appointments. It just shows up, and you better be ready. And the U.S. Supreme Court and the Second Amendment both recognize this, which is why if you go back to look at the Supreme Court's decisions, here's an example in the Heller case. In 2008, the Supreme Court said, in terms of discussing the operative text of the Second Amendment, which is the right of the people to keep and bear arms shall not be infringed, right? Quote, putting all the textual elements together of the Second Amendment, putting all the textual elements together, we, the Supreme Court, find they guarantee the individual right to possess and carry weapons in case of confrontation. Did you hear what I just said? Quote, unquote, in case of confrontation, because it's always a possibility. Well, the Supreme Court has gone on to say other things along these lines. Let's take a look at what they said in Nysurper versus Bruin in 2023. Quote, we now turn to whether the plain text of the Second Amendment protects the plaintiff's proposed course of conduct, which means carrying handguns publicly for self-defense. We have little difficulty concluding it does. Then he goes on to point out that the purpose of the Second Amendment, both in the home and in public, meaning outside the home, the purpose of the Second Amendment is, of course, to, quote, guarantee the individual right to possess and carry weapons in case of confrontation. Are you starting to see a theme here? In anticipation of the possibility of confrontation. And again, keep in mind that most of the time, if not all the time, we don't know when the confrontation is going to occur. So it's not like we can schedule it or prepare for it at a time. We can sort of prepare for it, but we never know what's coming. And that is sort of the problem with all these firearm storage laws, that they all anticipate that we somehow can say, well, we're not going to need our firearm tonight on Tuesday night because, hey, no criminal's coming on by. No rapist is knocking on the door. No one is stalking me today. But that's not how the real world works. And again, the Second Amendment and the Supreme Court recognize these realities. But let me carry on. The Supreme Court also goes on to talk about, this is not my language, this is the Supreme Court's language. Quote, the definition of to bear naturally encompasses public carry. They're talking about public carry here, but of course the idea is the same, in anticipation of confrontation. The Supreme Court goes on to say, quote, most gun owners do not wear a holstered pistol on their hip in their bedroom or while sitting at the dinner table. Now this is important. Although individuals often keep firearms in their home at the ready for self-defense, most do not bear them, meaning to carry them in the home beyond moments of actual confrontation. So you see, the Supreme Court, this isn't the Supreme Court in Bruin. They're literally saying that you can have a handgun in your home, loaded and ready for self-defense. They're not even saying handgun, they're talking about guns. In your home, loaded, unlocked, ready for self-defense. And that is the entire purpose of the Second Amendment. And if you have these laws that render firearms inoperable, lock them up, put them away, you can choose to do that, and that's perfectly fine. But understand, of course, that those seconds may play a role. Of course, it's all an individual choice. But the Supreme Court recognizes, and again, they anticipate that you're not going to know when evil strikes. So again, to be ready for confrontation means you have to have a gun that's operable and loaded. That's how I see it. I think that's how everyone else sees it, and the Supreme Court in the Second Amendment. Beyond that, let us actually look at the fact that the Heller decision in 2008 specifically contemplated and struck down as unconstitutional a trigger lock requirement, because the District of Columbia in the Heller case banned not only handguns in the District of Columbia, but they also said to the extent you had firearms in your home, they had to be locked up, they had to be maintained as inoperable, and they had to be unloaded. Well, this is what the Supreme Court said. Again, this is not Mark Smith, this is the Supreme Court. Quote, in Heller, quote, we must also address the District of Columbia's requirement as applied to Mr. Heller's handgun, that firearms in the home be rendered and kept inoperable at all times. This makes it impossible for citizens to use them for the core lawful purpose of self-defense and is hence unconstitutional, period, close quote. And is hence unconstitutional, period, close quote. That's the United States Supreme Court in the Heller case talking about D.C.'s trigger lock requirements, forcing one to have a gun in the home, locked and unloaded, and the Supreme Court struck it down as unconstitutional under the Second Amendment because, again, as I pointed out, what the Supreme Court has repeatedly said, a main part of the Second Amendment is to have firearms in anticipation of a potential confrontation where you have to use it to save your life. And if it's locked up in a drawer somewhere, it may not be as effective as if actually available to be used as a firearm. Now, the other thing I just want to make an observation about regarding Minnesota. Has anybody looked at the Court of Appeals that the state of Minnesota sits within? Has anyone noticed that the Court of Appeals for the state of Minnesota is in the 8th Circuit Court of Appeals? Has anybody also noticed the other states that are part of that? Well, that's states in addition to Minnesota, of course, North Dakota, South Dakota, Missouri, or Missouri, Nebraska, Iowa, and Arkansas. How many anti-gun liberals do you think are sitting on the 8th Circuit Court of Appeals right now? So does Minnesota really think that they're going to be able to pass some unconstitutional law and have no one notice it and slide it by? Or do you think they're going to find themselves in a gunfight, metaphorically, of course, a legal gunfight, ultimately in front of the 8th Circuit Court of Appeals? And how do they think that's going to work out for them? Well, remember, bad gun laws often give rise to wonderful Second Amendment precedents. If we didn't have that stupid gun ban in the District of Columbia, we would not have the Heller decision today in favor of our right to keep and bear arms. If we didn't have that silly New York decision basically saying you couldn't carry a gun if you weren't, special or a police officer in the state of New York, we would not have NYSERPA versus Bruin today as a Second Amendment precedent. If the city of Chicago had not banned handguns in their city, we would not have the McDonald versus Chicago decision that says that the Second Amendment applies to states and localities. So do you see how these silly, clearly unconstitutional laws, when they get enacted, often work out for the best for the Second Amendment community and blow up in the face of the anti-gunners? I suspect that if Minnesota decides to do something like this could very well happen. I also want to make one additional observation about something that kind of caused me to guffaw in this draft statute I saw out of Minnesota, and that involves transfer of weapons, specifically requiring that when you transfer a firearm to another person, you have to provide a locking device unless they already have it. But what's interesting that I got a guffaw out of is this sentence here as part of this proposed law. Who knows if it's going to pass or not, of course. But it goes on to say, quote, the transferee, which is the person getting the gun, right? The transferee must own a sufficient number of locking devices to secure each firearm the transferee owns. Ha 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 ha. Who comes up with this stuff? Who's going to tell the state of Minnesota, or anybody else for that matter, how many guns they actually own? You're going to tell, how's it even going to work? Walk me through how this is possibly going to work, right? Set aside the fact this probably violates the Second Amendment, because there's no historical analog that would justify such a thing. Set aside the fact it probably violates the United States Constitution's Fourth Amendment prevention, right? The government is prevented from engaging in unreasonable searches and seizures. And explain to me how this doesn't violate the Fifth Amendment's, right not to incriminate yourself by telling the government stuff that could get you in trouble. Obviously, in addition to all that, as a practical matter, no one's going to tell the state of Minnesota anything about the guns they own at all. It's simply impractical. This just goes back to the point that I'm guessing that the people that are proposing these kinds of laws are not interested in public safety. They're not interested in actually helping save lives. They just want to harass gun owners because they don't like their right to keep and bear arms. They don't support the Second Amendment, and they think that, frankly, probably only police officers should have guns. That's my speculation and my best guess. I don't know any of the people proposing this stuff, but it certainly seems kind of like an absurd suggestion as I see it. And I should note that I did do a little bit of search, and it looks like a whole bunch of sheriffs in parts of Minnesota have already come out and said that they oppose these proposed new laws on the grounds that they're unnecessary and likely unconstitutional. And I think that's basically where I come out on the topic as well. So, okay, folks, I hope you learned a little bit something about trigger locks. We don't do enough talking about trigger locks and, firearm storage laws. So, hopefully you learned a little bit something about this concept using Minnesota as our example. Of course, these arguments would apply to other states that are looking to do something like this as well, which means to convert your firearm into a rock or a hammer by making them inoperable when you need them in case of confrontation, as the Supreme Court has pointed out is your right under the Second Amendment. Okay, folks, if you haven't subscribed, please do so, and we'll see you again soon here at the Four Boxes Diner.
Orders up. Table 2A.